Hi, my name is Kenneth Trujillo Jameson, and I'm a partner at Willenkin LLP. I wanted to give you an update about a case that was recently argued before the Supreme Court in the copyright context, which deals with the issue of the damages bar for copyright infringement claims. In Warner Chappell Music versus Nealy, the Supreme Court set out to resolve a split among the courts of appeals on an issue that applies to copyright infringement claims that accrue under the discovery rule. And the question they were deciding is whether for claims that accrue under that rule, whether the plaintiff is allowed to get relief for infringements that occurred more than 3 years from when they filed suit, or whether they're limited to only 3 years of relief. At oral argument, it became clear that certain justices of the Supreme Court really are interested in whether the discovery rule should apply at all to copyright infringement claims. That is a question that presented itself recently in the Rotisky versus Clem case, where the Supreme Court cast doubt on discovery rules that apply when there's not a clear statutory hook for them. And several justices questioned whether they could decide this appeal at all without first deciding that preceding question, and that question wasn't squarely presented in this case. There's another cert petition in Hearst Newspapers versus Martinelli that does squarely present the question whether the discovery rule should apply to copyright infringement claims, and the Supreme Court has not yet acted on that cert petition. The court could have dismissed the Warner Chappell Music appeal as improvidently granted, but it hasn't done so yet. And to me, that signals that they're still trying to find some way to issue an opinion in this case, despite the qualms and the questions that they were presenting at oral argument. And so I'll be keeping a close eye to see when that opinion comes down and how it may impact plaintiffs and defendants in the copyright space. Thank you very much and have a great day.